Let me introduce Mike Tauscher. He's a partner with Scopelitis, Garvin, Light, Hanson, and Feary. I think that's all of them. And Tauscher. It should be Ann Tauscher. With over 35 years experience representing and advising transportation companies and other businesses in federal, state, and local courts and administrative agencies. He has spoken to various industry groups and at seminars on topics such as wrongful discharge, employment discrimination, workers' compensation, freight claims, and no-fault insurance. He focuses his practice on civil litigation for various segments of the transportation industry, concentrating in the areas of employment, workers' comp, and personal injury. So please welcome Mike Tauscher.
Okay, thanks everybody for being here. I appreciate the opportunity to be here and chat with you about a couple topics having to do with your company model in terms of employees or drivers rather. Are you going to have employees or are you going to have independent contractors? But before I get into that, I'd like to tell you a little bit about our law firm. Scopelitis is the nation's leading transportation law firm. We have almost 100 attorneys, a dozen locations. We're Midwest centric. Our headquarters is in Indianapolis, but we have offices in Chicago and LA, DC, that covers the coast, and of course a Michigan office, which I'm one of the two attorneys in it. And when I say we're a leading transportation firm, that's because we're transportation centric. We started off years ago with lawyers who did transportation, did the regulatory stuff. And as things changed, deregulation in the 80s and stuff like that, we pivoted and have grown. And what we have is a lot of people with a lot of expertise in a lot of traditional law areas, but we come at it from a transportation focus. For example, I have colleagues who are experts in tax law, former IRS attorneys, but what they know is trucking and transportation taxes. Okay. I have colleagues who are good at forming and selling businesses, but again, they come at it from a transportation focus because transportation has a lot of regulations. Okay. When you sell a transportation business, you have to transfer title. You've got authorities and stuff like that. And there's all these different aspects of transportation law that a lot of law firms don't get, but that's what we do. Okay. And again, as I indicated, what I'm going to talk about this morning is choosing your company model, employee drivers, or independent contractors. I'll tell you right up front, if you don't pick up on it as we move along, our firm has been big advocates of independent contractor model for a long time. Independent contractors have a long history in trucking. And it's something that you've seen and heard is under attack now. AB 5, everybody's heard about in California. Last week, the Biden administration's Department of Labor came out with new proposed regulations. They're talking about the gig economy, but it really is just independent contractors. And again, trucking is a focus. Okay, there we go. All right, employee driver versus owner operator. Here's a couple of the principles to think about. Okay, one thing, I'm not going to talk about the nature of your business entity. For example, are you a corporation? Are you an LLC? That's a topic for another day. We're going to focus on the core of any business, and that's your personnel. Okay, and in trucking, you do have to have a back office. You do have to have sales. You do have to have support, but it's drivers that are the core of your business. So are you going to have employee drivers or are you going to have independent contractors? Okay, some of the indicia of employee drivers. Drives a semi-truck provided by the employer. That's a key point. Picks up loads assigned by company dispatch. The main responsibility is to pick up and deliver assigned loads, i.e. follow the directions of the company owners, company management. Employees don't pay for any of the costs. Okay. They're usually paid by the hour, sometimes by the mile. But that paid by the hour, if you get in an audit of any sort, whether it's an unemployment audit, a workers' compensation audit, an IRS audit, employment by the hour is bad. You're not going to be found to be an independent contractor if you pay by the hour. We'll talk about that a little bit more later on. In terms of owner operators or your independent contractors, here's the key. They own and operate an independent small business, which includes a truck that they either bought or one that they lease. Okay, an independent small business. That's what your owner operators, your independent contractors are. And as long as you keep that principle in mind and support those drivers in that effort, something I think Mike talked on, then you can sustain your independent contractor model even in this current era where it's under attack. One thing about the independent contractors, freedom to select their own freight. Okay, pick their own loads. One thing big difference that sometimes folks have trouble with in terms of employees versus independent contractors is you do have to allow your independent contractors freedom. Okay, the hallmark of an independent contractor is that they are responsible for the result. Okay, you inform them that there's a load available going from point A to B at such a rate. It has to be delivered by such and such a time frame. Okay, how they get there, how they do it, how much they pay for their fuel, how many times they stop, as long as they accomplish the goal of A to B within the time frame. Okay, that's the hallmark of an independent contractor. They're not being told you must take this route, you must do this, you must do that. Okay, an owner operator, they're a business owner. They're responsible for all expenses. And they generate their revenues typically by mileage, or again, the best way to pay an independent contractor is by the load, by the task. Okay. Employees, again, going back to the hourly model, when you pay an hourly wage, they get paid an hourly wage no matter what they do, how efficiently they do it. They just show up and they get paid for the time they're there. The hallmark of independent contractor is they get paid by the task for what they accomplish, the delivery from point A to B. Okay, other considerations. If you're a motor carrier and you choose to go the independent contractor model rather than use employee drivers, you have to separate the concept of control. Okay, control the employee, as I just mentioned a moment ago, it doesn't work very well with independent contractors, particularly when you're being reviewed or audited by other folks, the IRS, unemployment, workers' comp. Okay. Whoops. Sorry about that. Okay. I mentioned up there about employee handbooks. Okay. You can have a similar handbook, but you have to modify it. And it's better to call it a contractor handbook than employee handbook. And it can't be quite the same detail because, again, the independent contractor has to be able to control the method of achieving the result. Okay, but one thing you can do, but you have to be very specific about it, is you can hold an independent contractor who accepts a load to your customer's expectations. Okay, you communicate the customer's expectations. That's not controlled by you. That's passing on by you the expectations of the customer, such as when they're supposed to be there, how they tarp a load, how they set the temp on a reefer load, those sorts of things. You're entitled to pass that on, and it's not supposed to be considered an issue of control. You have to be aware, though, that sometimes if you get in litigation, whether it's personal injury, workers' compensation, whatever it may be, courts sometimes look at the right to control, not just the actual control. They have to realize in a court case, the criteria a court uses to evaluate the status may be different than agencies might use, such as workers' compensation, unemployment, IRS. That's one thing that makes it somewhat difficult because, as you'll see in a few minutes, there's a lot of different tests for employees or independent contractors, particularly in the state of Michigan, and lots of times they conflict. And what you have to do is you have to navigate your way through and pick the best business model and the best aspects of it in order to make independent contractor model successful. Okay, Michigan has multiple definitions of employees. Okay, this part here, I want you to promise me that you're not going to let your eyes glaze over and fall asleep on me as I try to run through these rather quickly. Okay. The first one, unemployment agency, the UIA. Okay, if you have employees, you know, you have to pay your quarterly taxes on unemployment or whatever. If you have ever had an unemployment claim, you maybe had to contest it or whatever. But unemployment agency has this definition. Whoops. Try this again. Okay, service performed for remuneration under any contract of hire, written or oral, express or implied. And you'll hear this a lot in the next few minutes, the economic reality test. That's a test that's used in a lot of different contexts in the state of Michigan and, for a matter of fact, across the country. But the hallmarks, the economic reality test, they look at, whoops, get the hang of this yet, the control of the worker's duties. How much control is there? Okay, payment of wages. How is it paid? I mentioned a few minutes ago, hourly versus by the task, by the load, by the mile. The right to hire and fire. Okay, you hire and fire employees, but with independent contractors, you should have a written contract, something we'll talk about later, but you terminate under the terms of the contract, and it's a two-way street. Independent contractor can terminate the contract too. An employee can quit. Okay, and then the right to discipline. Okay, there's ways to handle that with independent contractors where it's not discipline, but it's an economic consequence for not fulfilling their contractual obligations. Okay, that's how you have to set things up if you're using independent contractors. You can't fine them because they're late. Okay, but you can set up a scenario where they're not fulfilling their contract and they have a contractual liability as a result of not fulfilling that particular obligation. Okay, minimum wage. Okay, again, a different definition of employee, but whoops, man, oh man. Again, they use the economic reality test. So that's two different agencies, the state of Michigan, use economic reality. MIOSHA, okay. Employee means person permitted to work in any employer. Talk about broad definition, okay. And MIOSHA doesn't differentiate really between employees and independent contractors. Okay, case law interpretation, again, anybody receiving financial return is considered an employee. Tax, okay. Mike touched on taxes or whatever. You got to stay up to date on that stuff, whether you're an employer filing your quarterly 940s or you've got independent contractors who are working with you. You know, you need to assist them, as Mike suggested, in making sure that they keep up on their obligations, because failure to do so can lead to all sorts of unpleasant consequences. But in the Michigan tax code, they define employee according to what the IRS says. Okay, and the IRS regulation, the most important part is, so whether the employee right to control and direct not only result, but the details and means by which it's accomplished. I mentioned that a few minutes ago. Independent contractor decides how to do it, whereas an employee is told how to do it. Okay, factors to consider. The right to discharge. There's actually 20 IRS factors. You may have heard about that. I'll talk about those in a few minutes. But some of the principal ones, right to discharge. And right here, I think is the most critical aspect of establishing drivers as independent contractors, and that supplies the tools of the trade. Okay, what's the tools of the trade for a truck driver? It's the truck. Okay, trucks are big time investments. Okay, and that's the hallmark of an independent contractor. Do they own or lease that truck? We'll talk about that a little bit more. Okay. So far, I think we're up to 5 different definitions in the state of Michigan, maybe around to 6. Workers' compensation. This is where your eyes may glaze over. I'll try to get through it quickly. Okay. If you have employees, workers' compensation is a concern. If you have independent contractors, it's not supposed to be a concern because they're not employees and they're not eligible for workers' comp. But out in the real world, what you find is an independent contractor who has downtime because their truck's not working or because they've gotten hurt. Okay. They don't have health insurance because they chose not to take on that expense, and they're not getting income. All of a sudden, they've been an independent contractor for several months, several years, but now they're an employee because their back's against the wall and they file a workers' compensation claim. Okay. That's a topic for a whole different webinar, but it's something to keep in mind because the definition of workers' compensation then comes into play, or definition of employee under the workers' compensation. Okay. One of the questions is there a contract of hire? That's where you start with workers' compensation. Okay. 4 different tests. Michigan's great at creating different tests. So we had one from pre-1959 was a control test. Then for about 40 years or so, you had the economic reality test. There's an 8-factor version. There's a shorthand 4-factor version. Then in 1985, the legislature tried to make a definition, a statutory legislative definition, and it's done in the negative, so it's hard to read, hard to understand, but it's right up here. If a person maintains a separate business, or the way they put it, does not maintain a separate business, does not hold themselves out to and render services to the public, and is not an employer subject to the Workers' Compensation Act, then they're an employee. So the key there is if any one of those 3 things exists, they are not an employee, they're an independent contractor. Court of Appeals, 1992 said you only have to satisfy one of those. Later, a different Court of Appeals panel said, no, you have to do all 3. Finally, the Supreme Court said, no, that court was right. Okay, that took about 10 years. But then what happened? Okay, they went and changed it again. But there we go. Now, what they did, they made a change to both, the legislature made a change to both the Workers' Compensation and Employment Act by saying, we're going to adopt the IRS 20-factor test, and that's how you determine whether somebody's an employee or an independent contractor. But then, in a case from this side of the state, Western District of Michigan, this Max Trucking, I'll talk about that a little bit later on another point, but what they said was, no, that 3-factor test only applies in the workers' compensation hearing context, the Workers' Compensation Bureau. It only applies in unemployment agency in those contests. What applies when you're in court as opposed to an agency? Well, you go back to the 3-factor test. So now they both can apply, but it depends upon where you are. Okay, and the Michigan Court of Appeals, a few years after Max Trucking, agreed with that. It says the 20-factor test only applies in administrative tribunals, but in trial courts, the 3-factor test applies. Okay, where are we now? The venue and the context are important. Are you in front of an agency, or are you in court? Is it unemployment? Is it workers' comp? Is it a workers' comp premium issue, arguing with your insurance company as to whether an independent contractor or driver's independent contractor employee? All these things are factors. And then it gets different when you try to determine employer status. Is a company an employer? Well, they use the economic reality test. Okay, yet another area that has big impact on trucking is Michigan no fault. What do they say? Well, they say the economic reality test. Are we confused yet? Okay. There's a lot to pack in and unpack in Michigan when you're trying to determine whether a driver is an employee or independent contractor. But more important, when you're trying to set up a system where you're going to use an independent contractor model, we have to wade through all these different things. And it's not fun, and you really do need help and guidance on it. Okay, here's another thing to think about before we get into best practices and what you can do. And that is, and Mike touched on it a little bit, there's big issues out there about misclassification and alleged payroll and unemployment fraud. Okay, one thing, it's almost ancient history because it's 2 administrations ago, but during the Granholm era, one of the first things they did when she took office was she created a task force, the Interagency Task Force on Employee Misclassification. Okay, briefly, what they did is they held so-called public hearings across the state. The people that testified were business agents for the Teamsters and construction unions, and all they did was get up and testify. It's horrible. All the employers are misclassifying. They're stealing, they're stealing wages from the employees. They're defrauding the state because they're not paying unemployment taxes, et cetera, et cetera. And as you might suspect, when they came up with their recommendations, it was all about how we must do something about this terrible misclassification thing that's being foisted upon the state of Michigan by the construction and trucking industries. One of the things that they recommended, which drove me a little crazy at the time, but as we fast forward from 2008 to today, you're not surprised. One of the recommendations was that high school and college curriculums should have mandatory training on employee rights and responsibilities so that young people won't be tricked into working as independent contractors, because the best thing to be is an employee. Okay, the task force was disbanded by Governor Snyder, but in 2019, when we switched administrations yet again, January 2019, they started a new, wasn't a task force, it's a payroll fraud department in the Office of Attorney General. And they go back to the misclassification that the Granholm administration was all about. They charged an employer of felony tax fraud in 2020. It was resolved in 2021. Okay, our Attorney General, current Attorney Generals, joined with multiple other Democratic state Attorney Generals in trying to repeal some federal FLSA and DOL independent contractor definitions. And of course, as we saw last week, the Biden administration's come out with a proposed rule. Even here as recently as April 2021, the state of Michigan purchasing guidelines have been revised. If you do a contract with the state of Michigan, you have to certify the classification of your workers as either employees or independent contractors. And if you do that, they demand a whole bunch of stuff to try and to make you prove that they really are independent contractors. Okay, one thing else you have to worry about is unemployment audits. Okay, how do they happen? They can file for unemployment. Here's something a lot of people don't realize. Michigan was one of the first states to do it with the IRS. They share 1099 filings. Okay, so the IRS supplies that to the state of Michigan so they can review it, and anybody who files a certain number of 1099s can be subject to audit, where they come at you and say, prove it. Okay, again, the IRS started sharing information with the states. They're increasing their audits. Mike talked about the Inflation Reduction Act with the hiring of the 87,000 IRS employees. Well, that's at the federal level, but beware, it happens at the state level too. Okay, that's the scary stuff. So what do we do about it? Okay. The best practices, excuse me here. Come down to a couple points. One is the tools of the trade, as I mentioned earlier. The hallmark of the independent contractor is owning the tools of the trade, your truck. If you're going to set up an independent contractor model, you got to get that driver to have his own truck. He either buys it himself or he leases it himself. That's the best way. That's the gold standard. Okay. The next best standard, lease to own. Those programs work, though they do have a high failure rate. That's where you need to support your independent contractor drivers so that they can be successful small business people. But in Michigan, that Max Trucking case that I mentioned earlier, there was a lease to own situation that the court found had too many hallmarks, too many indicia of being employees. So they found the people not to be independent contractors. Part of the reason there was Max Trucking was the one doing the leasing of the trucks. The motor carrier owned the trucks and leased them directly. The way you get around that is you need to have a separate employee leasing, or excuse me, equipment leasing company. It can be owned by the same people on the motor carrier, but it's the company that owns the equipment that does the lease. And then the owner operator leases it back to the motor carrier in a triangular sort of thing. If you go direct motor carrier to driver, that's where you're going to have it most likely found to be an employee, not an independent contractor. And the worst thing is company owned vehicle. You know, you can hire me to help you if you got an unemployment or workers' compensation audit, but if you own the truck and they're driving it, good luck. Okay, which test do we use? Oh, let me back up one thing. I didn't put it on here. Another thing about you can do for best practices there, I mentioned it briefly, is how you pay. By the task is a hallmark of independent contractor as opposed to by the hour. The other thing is you need to set up policies and processes, okay, to help these drivers be successful as small business people if you're going to use the independent contractor model. Okay, but one thing about any policy or process, whether it's your employee handbook for your actual employees, whether it's your contractor handbooks for your independent contractors, if you have a process, you have a policy, and you put it in writing, you have to follow it. You have to follow it. The worst thing that happens to me as a trial lawyer is when I'm involved in litigation and the plaintiff lawyer is able to hold up that policy book, whether it's for employees or independent contractors, and say, Mr. Company Owner, is this your policy? Well, why didn't you enforce it here? So if you have a policy or procedure, you got to follow it. Okay. What I advocate is a hybrid, test where you take the economic reality and the IRS 20 factor. This is a IRS guideline from 1997. They also had a 1995 for the trucking industry, but this one for the limousine industry. It identifies out of those 20 factors, 2 that are critical, 3 that are significant. If you focus on those in setting up your independent contractor process, you have a good chance of sustaining the independent contractor model. And last thing in best practices, the contract. You need a solid contract with your independent contractors. The ICOA, Independent Contractor Operating Agreement. It's got to cover all the basics. It has to stay away from control. Okay. You have some things such as mutual termination rights, etc. Again, the contractor's responsible for expenses, contractors responsible for results. Okay. And one last thing I'd say about that is that the best way as a small business trying to establish an independent contractor model is to have a good team supporting you. Now, this pains me as a Michigan State grad to quote Bo Schembechler, but he has a famous saying, the team, the team, the team. And that's really the case here for you guys. What you need is a team. You need a banking relationship. You need an accounting relationship. You need a insurance relationship. You need an attorney relationship. You also need support from other aspects such as payroll and such. Because those, but you also need people in that team who know your industry, that know transportation. Okay, you need a transportation-centric insurance company. You need a law firm like ours that does transportation. You need a banker that understands your business as opposed to other businesses, so they can help you with your business model. Whoop. That's my signal to stop. So we'll have time for questions a little bit later. I hope I didn't have your eyes glazed over with all those different tests, but I think it just helps to illustrate that it's a complex area, and don't be reluctant to reach out for assistance. There's a lot of outfits, a lot of entities out there, mics, that mic, this mic, this mic. Okay, we can all help you guys, and that's what we're here to do. Thanks very much.